The Information Technology and General Services Committee will now come to order. We apologize for the late start. The City Council meeting went a little long today, longer than usual. With that, we tried to notify as many of the parties that have been tracking item number 5, that item will be put over for 2 weeks and be heard in this committee in 2 weeks. That's item number 5. We will not be opening up that item for discussion or the agenda today. We are putting that item over for 2 weeks. That's item number 5. Okay?
Yeah. PD here.
We'll next go to item number 1 on the agenda.
Item number 1, GSD report relative to authorization to negotiate and execute a new lease for office space at 9911 West Pico Boulevard for the Department of Transportation.
Chuck Rubin, Department of General Services. This is a lease renewal for DOT's parking adjudication office in West LA. We were able to negotiate favorable terms. The rate on the new lease is actually the same as we've been paying on our month-to-month extension. Given the west side, even though a softer market, this is still an excellent rate, and we request your approval.
On the west side, what would be a realistic rate but not so excellent?
Probably $2.50 or $2.75.
Okay, so we're looking at $2.03?
Correct.
Okay, so we're looking at having negotiated a rate that might be 50 to 70 some cents cheaper than what perhaps a tough negotiator on the other side of the table may
Yes.
extract from us.
Correct.
Okay, all right. Is there anything else you'd like to let us know about this lease?
No?
Okay. With that, as a recommendation of the chair, since we do not have a majority in this committee present, we'll go forward to approve the GSD report.
Thank you.
Item number 2.
Item number 2, City Attorney Report and Ordinance relative to amending Article 4 of Chapter 1 of Division 7 of the Los Angeles Administrative Code to implement the GSD's Own a Piece of Los Angeles initiative for fiscal year 2008-2009 concerning the sale of surplus city-owned real property remnants.
Good afternoon. I'm Annette Bogno with the Deputy City Attorney with the City Attorney's Office, Real Property and Environment Division. Before you is a report that's submitted by the City Attorney's Office. Attached to it is an ordinance that implements an initiative that was already approved by the City Council. It's termed the Own a Piece of LA initiative. It deals with city-owned remnant surplus properties. The idea being that typically a sale of city-owned real property that is deemed surplus has to go before the City Council and be approved individually. And the CAO report has to accompany that approval. This particular ordinance carves out an exception to that for very small, what we call remnant properties, which are defined to be either, less than 5,000 square feet and not a legal lot size, or else less than 10,000 square feet with no legal access. And if it meets that definition, the idea here would be that this General Services Department manager would submit a report to the Municipal Facilities Committee, and MFC would be authorized then to approve that sale, and it would not have to wind its way through the council process as well. There's estimated that there's about 250 of these properties, and that report has gone before council, and it was initiated by the Department of General Services. So this is the technical cleanup that implements this whole program that's been previously approved.
Okay. And so when it comes to the value of these properties, they're evaluated on a formal appraisal basis, or they evaluated based on just the generic understanding of what the property's value is?
The Department of General Services would estimate the fair market value based upon, what a reasonable buyer and seller would be willing to negotiate. To the extent that these are remnants, I don't anticipate that the value is going to be extremely large in any given situation, especially if you don't have any access legally to the property but for this person that has the adjoining parcel. So that's part of the reason why we had recommended that you go ahead and go through a process that's streamlined, because these are not going to be commanding a very large sales price in most cases. I think that total estimate, I don't know, the Department of General Services has that in their report as to what the total income would be on this, but I think they projected $600,000 for the first budget year, and probably another $600,000 as they move along.
That's it. Yes, Reginald Jones Sawyer, Department of General Services. We estimate that all the parcels will become to $1.2 million if we're able to sell them all.
Okay. And you mentioned about landlocked properties.
Correct.
It's my understanding that in this country, if you own a piece of property, you are legally entitled to have access to that property, even though it would require access through another private property. It's my understanding that there is no true landlocked property in this country when it comes to access.
I believe that the law would vary from state to state.
Well, California.
In California, there is a case that came down within the last 18 months, I believe, in which the court upheld a property owner's defense against being subject to an easement that would be imposed upon him. And his neighbor was trying to gain access to his property because it was landlocked, and the court said, no, you can't do it.
What level of court was that?
I don't recall which level.
But so it hasn't gone all the way to the Supreme Court yet? Hasn't gone?
You mean the California Supreme Court?
Yeah.
It's quite possible that it did. I could pull that for you. But
Yeah, that's important to know. That's important to know
right.
because I'm going off of recollection that when I was involved in selling real estate, that court case, it was a long time before 18 months ago, that court case did not set that precedent. The precedent back when I was involved in real estate, in which I'm using that recollection
Right.
to understand what we're doing here, is that there was in California no true landlocked land. You did have the right to have access to it. You couldn't dictate to your neighbor that you get to drive, a semi-truck through there, but the thing is you did have to be able to have access to your property. So it's important to me that before we get to council, if you could brush up on that and be able to explain to us what the true aspect of landlocked is, because obviously we own landlocked property. And obviously if people are not allowed access, that grossly diminishes the value
Yes, it
of
does.
those properties, except to a neighbor. But then a neighbor wouldn't have to pay very much because they're the only ones that would give it value, so therefore it's kind of like a catch-22. You're stuck with a piece of property that has no value except for the person who is adjacent to it. If they bought it, then it would enhance the value to them tremendously. Okay. Anything else, Mr. Sawyer?
That's it.
Okay. All right. I don't see any public comment cards on item number 2, unless that's an upside-down 5. Item number 2, no public comment cards, so we'll close public comment on item number 2. And with that, we'll approve the city attorney report and adopt the draft ordinance. And we look forward to that report when this comes to council on the landlocked issue. Thank you.
Thank you very much.
Thank you. We'll move to item number 3.
Item number 3 is continued from July 7, 2009. Motion, Han Parks, relative to issuing a request for proposals to identify a developer for the establishment of the Lansett Industrial Park on city-owned property at 930 East 111th Place. The Housing, Community, and Economic Development Committee has waived consideration of this matter.
Okay, can somebody bring us up to speed as to how we came to the point of the status that we have on this property?
Ninus Benjamin from Community Development Department. This property was acquired in 1994 by GSD, and they would use CDBG funds, which is administered by CDD, and at the time CRA and GSD were the lead agency for this acquisition. They did do an appraisal at the time, and the property was acquired at the appraised value at the time. This property was very deep, and subsequent to acquisition, city has spent money to put a cul-de-sac street accessing the property to its depth. It's called cul-de-sac, and also brought utilities from curb of the street to inside the property. And also remediated the grounds for an industrial development. Remediation work for the underground water still is need to be done. To date, city has spent total of $5,332,000 so far, of which $3,677,000 are CDBG funds. And at this time, the aim is to lease the property and not to sell it, for a developer to lease the ground and develop the targeted industrial use.
So we're looking to hopefully get a developer who will commit to building facilities, erecting facilities on this property that would be of the nature of industrial, you said, or?
Right now, the property is zoned for light industrial, correct?
Okay, light industrial. And what was the property appraised at when we acquired it?
When the property was acquired at $2,250,000, I do not have all the files, but from my general knowledge of acquisition process, it should have been appraised at least to the amount of acquisition price. Could not have been appraised less than this.
What's the current appraised value of record now that we're the owner?
A year ago, we commissioned through CRA a current appraisal report for the property. Property is appraised unreasonably low, $600,000, which we find no reason. We don't like that appraisal value, and we don't intend to go for the sales approach.
Okay. Is there anybody in the room who has any more details on how we arrived at that appraised value?
David Roberts, General Services. We originally appraised the property without the damages to the environmental soil, and afterwards they appraised it with the damage. Excuse me. Therefore, there's a large discrepancy.
Okay, but when we get a developer in this proposed plan, when we obtain a developer to develop this property, should that occur, are we expecting the developer to clean up the land, or are they basically going to have a land that has finally been cleaned up and then be able to build on that?
Well, my understanding was that the developer was going to agree to buy the property if the city was going to pay for all the environmental cleanup work.
Exactly.
So there was a major discrepancy because it was originally appraised at, I believe, $5 million. But they had calculated the cost for the remediation to be about $4.5 million.
But who's going to pay for that remediation? The city or this third party?
The city.
Okay, so if the city has a property that it appraises, say, at $5 million, but then we realize, well, that doesn't make any sense because it's dirty property. It needs to be cleaned up. And all of a sudden, the city decides, well, we're going to spend several $1 million to clean it up. Doesn't it make sense that that property should be valued at something closer to $5 million and not $600,000 once it's been cleaned up?
It would seem to make sense that way.
Yeah, it would seem to make sense. All I'm trying to get down to the bottom of is, why is it, how many acres is this property?
9.06.
9 acres of real estate within the city of Los Angeles that is zoned light industrial. After being cleaned up, it appears that we're willing to accept the idea that this property only has $600,000 in value.
That's not our agreement, that's the CRA's agreement.
Councilor, may I?
Sure.
Okay, first, the value of the property, whether it is contaminated and is cleaned up, how much money has been spent to clean it up, does not make any difference in what is the earning potential of that property.
Yeah.
Okay. Now that it's cleaned and market rent can be leased, we do not agree also with the $600,000 appraisal done a year ago. Appraisal was done through CRA, was reviewed by CRA, Appraisal Review Department, that they told us this is good appraisal. We do not like that appraisal, that value. So we are not proceeding with the concept of sale because we do not know what the market value of the property is.
Yeah, but when you do a long-term lease with a developer, even though you retain the property in your name, and they're basically doing a long-term lease, the value of the property usually goes into consideration as to what kind of deal we're making with the developer. Look, I might be wrong. You do this on a daily basis. I'm just a councilman. I happen to touch on a gazillion different things on any given day, okay? Whether it's a Michael Jackson funeral and who should pay for it, or whether it's a 9-acre property and what the value is. So help me understand.
A potential lessor, in this case we are the lessor, a lessee will come in and lease the site for an amount that lease can pay. It all is a function of what kind of tenants we can attract to this property and how much market rent lease we can get from them. If this property was contaminated, the potential users are close to zero. So the question is not today's value so much. When we acquired this property, what was the contaminated site value and why we bought it? That's the question from 1994, which...
Well, I'm not going to go dig up old bones on that one. That's
Sure.
that's
tough.
history. All I'm talking about is, let me ask GSD. If GSD is aware of the idea that a property that is under your purview, that we're going to want to lease that property out on a long-term lease, is it relevant or not what the value of that property is at the time that we want to do a long-term lease with the developer?
It is relevant.
It is. Why is it relevant?
It's relevant because the value of the lease is based upon what needs to be done on the property. If the developer or the lessee has to work on cleaning up the property, there's a cost to them to do that.
So if there's a property under your purview, GSD, and you've cleaned up the property, et cetera, and now the city is going to try to lease it out on a long-term basis so that somebody can, say, do some manufacturing or something like that, again, is it relevant as to the value of that land, in addition to the relevancy of what the potential project that a developer could develop on that land? Are both of those relevant matters, or just the potential of what the person can do with it, such as improvements?
I think you have to separate between a business decision and how you're going to do a business versus what the property is worth, and I think that's what you're saying. Should there be a simple value for a business operation as well as the land that's being leased? In this case, I believe you're talking about a potential to lease this property once it's cleaned up, which it has been cleaned up correctly now, and who's going to pay for that cost cleanup? And the developer, whoever it is.
It's my understanding that the subject, item number 3, the subject property here, it's clear that the city of Los Angeles is going to pay for the expense of cleaning up this dirt,
We
correct?
have already paid clean, except for the underground waters, which is happening as we speak, and will happen next 5 years.
So who's going to pay for that?
We have to pay for it.
Okay, the city's paying for it.
$1 million, 5-year
Yes.
budget.
Okay. What I don't understand is why we're making quasi-final decisions on what to do with this land by the motion that's before this committee without having the value expressed on this property, an accurate value of what this property is worth as it will be turned over to a developer on a long-term lease.
Councilman, your question whether value is relevant is absolutely relevant. In making a decision whether to sell or to lease, you have to do cost-benefit analysis
Sure.
of lease is better for the city or sell is better for
Sure.
the city. See, we have gone so far, this property has gone through 3 RFPs for sale on page 2 of the report, and we have selected so far 3 different developers in order to reach a sales and development agreement with them,
Look, we're not selling the property anymore, correct?
and every one of them failed.
We're only looking to try to lease the property.
Because the
correct?
sales approaches have failed, value is not there,
Exactly.
transactions are not there.
Exactly. So let me just say this. As the process as it stands today, as far as you're aware, should the city council pass this motion and give your department the authority to go ahead and make a long-term lease with a third party, when you do so, will you be back before this committee
We are
before that is
asking-
finalized?
We are asking to do an RFP, come up with a proposal from a potential tenant to get council, your office, your
Okay.
committee's approval.
All right. So I'm just letting you know, since you don't have the answer to my questions today, I stopped caring. But I'm going to still ask those questions at the next phase when you're before me. So when you pick a developer and you try to give us a proposal, say, this is what we want to do with the property, ABC Development wants to do this with it, et cetera, this is the deal we struck with them, this is how much we're asking of them, et cetera, I'm still going to want to know how you arrived at that agreement and what parameters were in play when you decided whether or not the city is in fact going to get what it's worth out of this property, okay?
I understand.
So just be ready for that. Any questions? No. All right. All right, we're on item number 3. Public comment is open on item number 3. Anybody here to speak on item number 3? Seeing and hearing none, public comment on item number 3 is now closed. With that, it is the action of this committee is to authorize CDD to issue an RFP. Okay? With that, we will go back to item number 1. On that item, now that we have a majority of this committee present, we'll reopen that item for action to approve the GSD report. Approve? Okay. The majority of this committee approves that item, approves the GSD report. We now go to item number 2 for purposes of action. And the action this committee will take on item number 2 is to approve the city attorney report and adopt the draft ordinance. Okay, such is the case. Now we move to item number 4.
Item number 4, motion Rosendahl Wesson relative to the proposed acquisition of 2 parcels comprising the Bologna Lagoon from Via Marina and 250 East 62nd Street and related matters.
Okay. Anybody here from any relevant department on this item? Okay. Who would be taking jurisdiction of this? Is this a GSD matter, or who would be involved in this?
Reginald Jones Sawyer, General Services. The lead on this will be the city attorney's office, and they will pull together the relevant departments to effectuate whatever action to bring before this committee. I think right now, one of the first steps is for the Department of General Services to go ahead and perform a Class A appraisal. We've already begun talking to different appraisers to get the cost estimate so we can move forward with that. And then we'll bring that appraisal back to this committee, and then discuss it and bring something back to your committee.
Okay. And approximately how long do you expect this appraisal should take?
Probably 6 to 8 weeks.
6 to 8 weeks? All right. So within 60 days?
Yes.
8 weeks, 2 months, 60 days? All right. Okay. So with that, what we'll do is instruct the appropriate staff to report back in 60 days, inclusive of the Class A appraisal to be done by GSD, and it include the city attorney's office and all relevant staff from the city of Los Angeles to meet the needs and requirements of this particular motion so we can hear it before this committee. Okay, thank you. Any questions? Okay, so that'll be the action. Hold on, public comment on item number 4. Anybody here for item number 4? I don't see any public comment cards on item number 4. With that, item number 4, public comment is now closed. So with that, that's the action on item number 4, the instructions to the staff to report back in 60 days, as stated earlier. Okay? We did put item number 5 over for 2 weeks. The department, IT department, and relevant discussion should be able to be handled hopefully on that one day, rather than having it done in parcels, like what would have happened today. So that being the case, that concludes the items scheduled for today's agenda. General public comment is now open at this time for this committee. Is there anybody here for general public comment? That's issues that are relevant to this committee but are not scheduled on the agenda today. Seeing and hearing no one come forward or fill out any public comment cards, general public comment is now closed. With that, this committee is now adjourned.